our next case, which is case number 167162, Radke versus Charles Truesdale, DBA Truesdale Industries. This is also a mini oral argument on the application with 15 minutes of argument granted to both sides. Again, you have appellant, or both have 2 minutes of fire-free zone. Appellant, if you'd like to reserve some time for rebuttal, you may do so, but we just ask that you keep track of it yourself.
Yes, Your Honor, I will try. I would also like to reserve 2 minutes, please. Good morning, Your Honors. Drew Slager for Mike Radke and Kate Radke, the appellants. Mr. Radke's case shows that in practical terms, the open and obvious doctrine remains in place for claims by licensees. The duty owed to licensees essentially says visible dangers are not actionable, no matter how dangerous they might be. And that's what we seek to overturn in Mr. Radke's case. We do argue that there's a question of fact as to whether this open, uncovered hole constituted an unreasonable danger under Blackwell and whether defendant breached his duty. But the bigger, more fundamental issue is whether a danger's purportedly obvious or visible nature should remove a social host's duty of care when that no longer removes the duty for in the business invitee context. So we argue that the court should remove the licensee business invitee distinction in premises liability following the third restatement and other jurisdictions. And we argue that Mr. Radke's status as a volunteer that day should not have rendered him unprotected, should not render him unprotected. And in general, that the status of a permitted visitor, someone who has permission to be there, shouldn't determine what level of care the land possessor uses when that visitor comes onto his land. Instead, the jury should figure out whether the specific risk is unreasonable and whether the landowner breached its duty of care in that regard. And as Ms. Goldman touched on, that will give full effect to the comparative fault statute that the court considered in Candle El Sayed. That will give full effect to the principles that the court considered in Candle El Sayed in terms of not pointing the finger at the injured party's conduct and using that to remove the duty of care entirely. The third restatement is clearer, it's more predictable, like other jurisdictions have talked about, and it is not a radical departure. Stitt was decided 25 years ago, not centuries ago. And the court acknowledged then, the Stitt majority acknowledged then, that its holding was placing Michigan as somewhat of an outlier in that area. I think when you go back and read Stitt, there's not necessarily a clear justification then. There are the same broad appeals to history and tradition that we're hearing today, but in this context, those traditions, those historical factors don't really apply, and they didn't then, only 25 years ago when Stitt was decided. The other factor that Ms. Goldman touched on and that defense counsel touched on in the prior case is that we do have the benefit in this instance in Michigan of the fact that there is no duty to trespassers, right? If the third restatement is adopted in to some extent, there won't be a duty to trespassers because that's been precluded by statute. I think that's a good thing. The legislature acted to the extent it felt necessary, took away, frankly, the part I would have had the hardest time making any kind of argument about. I don't think that trespassers should be protected necessarily, and we don't have to worry about that because the legislature chose to acted to the extent it felt necessary. So homeowners, businesses, whoever, is not going to owe a duty to trespassers, and that makes our task simpler today, I think. So we have trespassers, and then we have everybody else who's allowed to be there, who's invited there. I think intuitively that makes sense. We see that dichotomy in other contexts, like with the dog bite statute. We see that dichotomy elsewhere, I guess, in terms of just ordinary negligence as well. And there's no modern justification for these differing duties to social invitees, people who are asked to be there, or public invitees, as we've talked about as well this morning, versus business invitees. So for those reasons, we would ask that STIP be overruled and that these categories simply be one more factor for the fact finder to consider when determining whether a risk is unreasonable and apportioning fault under the comparative fault statute that we use and that we held was important in Kendall El Sayed. But jurors can be and should be trusted with making that determination. Going back to some of the questions that were asked in the prior case, I think you raised an important point, Your Honor, Justice Welch, about homeowners that can feel like, you know, we're expanding the world of liability radically. I think, like Mr. Maher, I'm mostly practicing in the trial setting, or in the trial courts rather, and I think, to go back to something you said, Chief Justice Kavanaugh, I think that the way homeowners think about it really is, you know, once you've gotten to a jury, I think folks expect that if they invite somebody onto their property, they're going to be expected to take care of the property. I don't think most homeowners are walking around with this thinking that if they invite their next door neighbor over, they can have any level of danger presented to the neighbor and that's okay. Whereas if the mailman comes up the stairs because he's working that day, they owe a different level of care to that person. I don't think that they're necessarily thinking that way, and I don't think that they should think that way. I think that if you're inviting people onto your property, whether for a social reason or for a business reason, you should have that expectation that you owe the same duty of reasonable care.
So I shared the hypothetical about leaving some rakes in the backyard. It's snowbirds, they leave, everything gets covered with snow, and the neighbor, who's totally allowed to come on the property, they have full permission, they're checking the backyard out for down trees, totally well-intentioned, trip and fall on the covered rakes. How would that work under the third restatement in your view, if the plaintiff were to sue?
Well, so in that hypothetical, you're saying they're totally invited. I mean, are they invited specifically that day? Because if they are, then I think I can see the plaintiff's lawyer making an argument that it makes sense to make a warning, to say, hey, I did leave some rakes out. I mean, you know, it's a classic sort of cartoon danger. We can all visualize it. Hopefully you would mention something. Now, perhaps the homeowner who's away in Florida doesn't know that it snowed. In that instance, I think you'd probably have a viable notice argument. That's kind of an interesting law school type fact pattern, but I think you probably would have a notice argument, because in that instance you wouldn't be picturing that this other condition has changed the condition you left a month ago when you went south. So I can see there being hypothetical scenarios like that where a homeowner feels frustrated, but I think in general our courts and our juries are equipped to consider those things and to deal with that.
So would, under the restatement, could anything get kicked at C8?
I'm sorry.
So like, it seems, there's a duty assumed, and then obviously if there's an injury, that moves to the potential breach and obviously comparative negligence and the whole scheme that we have, understood. Does that mean it's always a jury issue? Can you ever get a case dismissed, a summary on C8 before you have to do discovery and all that?
I could be missing something, Your Honor, but I don't think there's any fact pattern that if the court adopted the third restatement would have been a C8 motion previously that now isn't. I think in practice, we're almost always doing some level of discovery to figure out even questions that really could end up being C8 issues later, but there's no real scenario where you get a real laugher of a filing in and you file an MSD right off the bat in a premises liability context. I don't think.
Yeah, fair enough. That's fair. And we see a lot of times 8 and 10 sort of getting conflated. Fair enough.
Agreed.
So then what about C10? I mean, does everything go to a jury? What would?
Well, Chief Justice Kavanaugh, I think, raised an interesting point that's getting litigated more and more now, which is that in an invitee context, business invitee context, defendants are saying, there's no unreasonable risk of harm. And what they're doing is often conflating that argument with the old severe risk of harm special aspect that used to be available as an argument under premises liability when we did have open and obvious. So I'm seeing those arguments a lot and being troubled by those arguments where they're just saying, well, okay, there's a danger. We know she tripped and fell on that danger, but we just don't think it's unreasonable. That I have a hard time with that, but I think there's always going to be room for the argument, no matter what. If you adopted the third restatement, I think there will always be room for the argument to say this isn't a defect in the first place. This was a curb that was built last year. That there is literally nothing wrong. It was approved by the city inspector. We built what we wanted to build. The fact that you tripped over it does not create liability. I think there's going to be room for that. But I do worry about that argument going too far and somebody saying, well, okay, there's a 3-inch crack in the sidewalk, but you shouldn't have stepped in it. That's not unreasonable. And some judges, I mean, I don't want to, but some trial judges who may have been more inclined to grant a motion on open and obvious are saying, well, okay, that seems to be an alternative path. So
Yeah,
that's always a tough balance.
I think that if you look at where the sort of term special aspects originated from Bertrand,
Yes.
talking about a common, ordinary set of stairs, right, that is dangerous or presents a risk of harm, of falling or injury, but it's not unreasonable because you need stairs to get from one level to another, or they're common, there's a utility. And in talking about, in fact, there were two distinguishable types of stairs, right? One had special aspects that made it actually perhaps unreasonably dangerous, which is not quite what morphed into the special aspects as an exception to open and obvious. But
True.
but you would agree that that framing or that including in defining the duty in such a way to still include an unreasonable risk of harm is not in fact what the third statement suggests doing, but it is something that Michigan has recognized in common law about as long as these distinctions have been, the visitor distinctions have been in existence.
I hadn't thought about that before today, Your Honor, and I guess just reading that language straight from the restatement of torts third, section 51, I don't see it, but on the other hand, that's if what we're asking for is kind of a uniform duty of reasonable care, I think I think that's still there, right? I think you very well still have a C-10 motion to say, I have met my duty of reasonable care as a matter of law when what you tripped over is meant to be there, serves a purpose, and you just happen to trip over it. I think you would still have that available. I mean, you're right. It's not phrased exactly the same way, but reasonable versus unreasonable, I think that C-10 motion is still there, I would argue.
So counsel, Iowa got rid of the
Yes.
the classifications, and in Koenig versus Koenig, the case involved a mother going to her son's home because he was ill, and she tripped over a vacuum that he had not put away. So this is why I think homes are, I see them as more challenging. We do sort of leave our house, and sometimes you leave it in disarray, and you can't maybe predict everybody who's going to come there, maybe a little different than a business where people are going to be coming through the doors. So under, what would happen in that case, under your standard? I'm assuming it goes to the jury to decide if it was reasonable to have the vacuum out?
I think more likely it would be settled for nuisance value, but,
Fair enough.
but it's yes, I think,
Two-step there.
but I can see, again, I mean, I could see a defendant filing a C-10 motion
Yeah, I'm just wondering,
similarly to
is
what
that
we talked
C-10
about.
worthy? Yeah.
Could you say, I have met my duty of reasonable care as a matter of law here, I'm allowed to be messy at my home and I don't know anybody's coming? Could that be granted? I think it could. I can also see it being a close call that goes the other way, and I can see how that would create frustration for a homeowner and their insurance carrier. But I also think when I look at a situation like Mr. Radke, who is there as someone who was invited to be there specifically, not just a son who happened to show up later, that the vastly different duty of care or level of legal protection that he's currently entitled to is not currently justified.
Thank you. You have 30 seconds for rebuttal.
Okay, thank you.
Mr. Tupper.
Good morning. My name is Tom Tupper, and I represent the defendant appellee, Charles Truesdell. I know the court asked us to brief 3 issues today, so I will only mention the facts as relate to the issues we were requested to brief. And I'll try to tie them into the questions that the justices have had so far. If we were to use the neighbor and the hidden rake analogy or hypothetical here, in order to complete the analogy with our case, the homeowner would have to have not known that the neighbor was coming over into his backyard, and in fact, a step further, would have reason to believe that nobody was going to be in his backyard, and have no reason to believe that the neighbor had any reason not to see the rake hidden in the yard. That's the fact scenario we have here. This is not a case involving protections or lack of protections for social hosts. Mr. Truesdell was not the social host here. Dr. Swenson, the homeowner, was a social host. He's been dismissed from the case, and neither of the Court of Appeals decisions dealt with the relationship between Mr. Radke and Dr. Swenson. The issue here is what duty did Charles Truesdell, the general contractor, owe to Mr. Radke when Truesdell not only had no idea Radke was going to be on the premises, it was actually a step further than that. Truesdell had reasonable belief that no one would be on the premises except for Dr. Swenson, and he was working on a separate part of the house. There's no reason for anyone to have been anywhere in the basement, anywhere near the opening to the basement. Now, this was, even Mr. Radke admits this was a house that was under active construction, and in the sequence of construction events, they had not installed the stairway in the opening from the garage to the basement. That was used, number 1, for a cement chute to pour the floor into the basement, and then later was going to be used to transfer the lumber down into the basement. The only people that were supposed to have been working in that area were the framers, who were going to be coming in the next couple of days, and they are required to use fall protection, which is harnesses and tie-offs. So constructing a barrier and requiring guys wearing harnesses and tie-offs to climb over a barrier is actually, it creates more risk. It's cumbersome, and it's not part of his obligation.
Counselor, I hear your frustration on the treatment, and so I'm wondering, here, Mr. Radke is treated as a licensee. I don't know if you're here for the prior argument, but,
Yes.
that individual is also treated as a licensee. And so, but you're saying, yes, these categories, we should keep them and they make sense. So why shouldn't it be that we would have a more nuanced understanding where maybe the plaintiff in the prior case, there's a greater duty to than what you're saying here? Maybe there's a lesser duty. It's more nuanced in terms of the facts of the case. So I'm just, why do those categories that treat Mr. Radke the same as exactly the same as the plaintiff in the prior case, why does that make sense?
Well, they are very different, and so I think that I guess I don't really want to speak to the facts of the Church of Magdalene case, but in that case, she was determined not to be granting a commercial benefit.
She was a licensee, yes.
Yeah, as I understand, and that really was not an issue in our case. That could have been an issue between Mr. Radke and Dr. Swenson, but that was, Dr. Swenson was dismissed from the case before. In our case, there's really, under the traditional classifications, there's really no question that Mr. Radke was a licensee. And again, Mr. Truesdell had no reason to believe he was there, had no opportunity to assess Mr. Radke's experience or knowledge of construction practices before he was walking around, had no ability or opportunity to determine if Mr. Radke had his own insurance that would cover him if he was injured on the premises. He simply had no knowledge of any of this. And so I think it's very fair to treat him, to treat Radke as a licensee as relates to Mr. Truesdell. And I think that it kind of goes back to what Mr. Maher is saying, was at the very core of our concepts of duty are the relationships between the party. And so adopting the third restatement just completely disposes of all of those factors that we analyze, sends everything to the jury. And, you know, you can argue that it's simpler, but it may be simplistic rather than simpler. Ultimately, how is a jury going to decide these things? Are we going to develop a whole new set of jury instructions to determine, to address whether they knew the licensee or the entrant would be on the land, whether the entrant had permission to be on the land, whether the landowner or land possessor gathered or earned some kind of economic benefit from their entry? It doesn't actually simplify it as much as it says. It just gets every case to the jury, and it will result in the same nuance and the same distinctions, just a bunch of new jury instructions to address all these issues, when we already have a hierarchy or sort of a classification system that works very well. Again, you can find some outlier cases that have some very strange results, but those are really just a small outliers in the entire universe of thousands and thousands of premises liability cases, and trial court judges are very capable of applying the law that we have established under STIT to these categories. And the Court of Appeals had no difficulty applying it to Mr. Radke here. It doesn't appear that even plaintiff argues that Mr. Radke was not a licensee. He had no relationship with Mr. Truesdell whatsoever.
Counsel,
If Mr. Truesdell had known that, you know, Mr. Swenson mentioned that there's somebody coming over, I have a friend stopping in, would that have changed the calculus for your
It
client?
could have, he would have given him an opportunity to warn him. It would have given him an opportunity to maybe be there at the same time to see what they were working on and make sure they weren't stealing his plank off of into the back door and traipsing around with it. Sure, it may have changed the calculus.
Thank you.
Sure.
Counsel, I'm struggling with something a little bit more fundamental from the stare decisis angle. I mean, today we've heard folks talk about overruling STIT and adopting the third restatement as if they are interchangeable. But it seems like it would be very different things. I mean, STIT is not, as I understand it, is not the first nor the most recent case from this court to uphold this common law trichotomy. And so is it fair to say that what we're talking about really isn't overruling STIT, it's just, are we adopting the third restatement or not? Because
Yeah. That's a good point.
it would be much more than saying STIT was wrongly decided, which question mark as to whether or not it was under the common law at the time. It would be more broadly, hey, we think third restatement is a better policy or whatever, and that's the analysis we're going through.
Yeah, well, I agree. I mean, this court, I don't have to tell you, as recently as 2023, reaffirmed those three categories in Candle El Sayed. And so the categories have existed for a long time. That has to do with the issue of the reliance factor, where the courts, counsel, and homeowners and home possessors came to understand their duty. So I think, yeah, it is a question of, do we just do away with those classifications altogether and adopt the restatement third with this one-size-fits-all approach? Or do we keep a system that is already more nuanced and more responsive to different factual scenarios? It's the product of years and years of fine-tuning, and it works. It worked in Mr. Radke's case, too. Again, if there's some argument that social hosts should have different obligations to guests, that should be decided in a different case, because that's the case against Dr. Swenson, not against Mr. Truesdell.
Counselor, Brother Counselor suggested in his opening that effectively for licensees, the open and obvious is still present, and I assume he means by that there's a duty to warn of hidden dangers in the test, and so I wanted to get you to respond to that.
Yeah, I think that's how I interpret it as well. The open and obvious, under the current classification, open and obvious really, to me, is sort of identical to whether or not a danger is hidden with respect to the duty owed to a licensee. And I think that's how the Court of Appeals on remand interpreted it as well, when it found that open and obvious is not a factor for a licensee, but Mr. Radke could not show that these dangers were hidden, so there's no breach of the duty. So I think that that's correct, Your Honor. Turning to and I would echo the comments of your brother counsel on the Molitaris case, appellee, and of the amicus case about the increased litigation and insurance costs. I'm sure the court has heard all of that. I just do want to spend a minute on the third issue that we were asked to address. If the status-based categories continue, whether there is a fact question on unreasonable risk of harm. And I know we do go back to the definition of unreasonable risk of harm, as the Chief Justice alluded to in, I think it was even before Stitt. But it has to be an unreasonable risk of harm that the licensee does not know or have reason to know of the hidden danger and the risk involved. And when we look at what some of the other cases have interpreted, that is that it's not just a dangerous hazard, but one that is unreasonably so. And it must be more than theoretically or retrospectively dangerous in hindsight, because even the most unassuming situation can often be dangerous under the wrong set of circumstances. That's Hoffner versus Langto. And in Bertrand versus Allen Ford, the court is to look at the character, location, and surrounding conditions to determine if the condition was out of the ordinary. So again, looking at this is a home that all agree is under construction. And at the stage of construction they were at, it was a rational choice to leave that stairwell open, both for the cement chute and for a means to transfer all of the lumber into the basement for framing. It was, again, plaintiff cites the MIOSHA regulations, but he did not argue that in the trial court. And even his expert admits that you can satisfy the MIOSHA requirements by wearing fall protection, harnesses and tie-offs, rather than a barrier. Those requirements are in the disjunctive, either or. And so there was no requirement that they build a barrier. And so looking at the character, location, and surrounding conditions here, and looking at Mr. Radke's testimony, he said that this opening was not hidden. He avoided it on his first trip to the platform to go and get the plank from the door to the garage. He came back and he said if he had dragged the plank a different way, facing forward, he would have seen the hole. He had the email that morning telling him that the framers are coming to finish the stairwell from the basement to the garage. There's nothing about this that was hidden, and if you can look at the photographs that have been attached, this is not a hidden condition, and therefore there was no duty owed to Mr. Radke in his status as a licensee. I think that's all I have on that issue, unless the court has questions.
Questions?
Thank you. Well, and we're asking the court to deny the application, or in the alternative to affirm the Court of Appeals decision on remand. Thank you.
Thank you. Mr. Slager?
Going to Justice Thomas's last question, really, this is a continuation and very much intertwined with the issues that were discussed in Candle El Sayed. And adopting a uniform standard for licensees and invitees will give full effect to the comparative fault statutes that we use, that we discussed at length in the Candle El Sayed case, and give full effect to the court's reasoning in Candle El Sayed. So for those reasons, we do ask that business invitee and licensee distinction be eliminated. Thank you, Your Honors.
Thank you. Case will be submitted. Thank you.